Ready, start. In the judgment of the case involving interfaith marriage, Srimati X and others versus the state of Madhya Pradesh and others, delivered on February 13, 2026, Justice B.P. Sharma has, in the facts and circumstances of the case, thought it appropriate to dispose of the writ petition with direction to the superintendent of police to take appropriate steps for providing protection to the petitioners for their safety of life and liberty in accordance with law. Para. In the High Court of Madhya Pradesh at Jabalpur, it has been the case of the petitioner couple that they are major and Hindus by religion belonging to different caste and society. Para. The petitioner one belongs to Yadav community. However, the petitioner two belongs to Kushwaha community. Para. The petitioner's marriage was solemnized on January 9, 2026 from the Hindu Vivaha Sansthanam Samiti, Bhopal, as per Hindu rites and rituals with consent of each other without any pressure, fear, and greed. It was pointed out that the family of the petitioner number 2, along with other members of the community, were attempting to initiate criminal proceedings against the petitioner. It was submitted that the respondent number 3, the father of the petitioner 1, was unnecessarily harassing and torturing the petitioners by compelling them to dissolve the marriage. He lodged false complaint before respondent to against the petitioner 2. It was submitted that the petitioners were legally entitled to marry and reside with a person of their own choice. The petitioners have solemnized their marriage in accordance with the social customs and presently living together in peace. No person or authority has right to interfere with the realization of that choice, even otherwise obstructing an individual's right to choose their partner amounts to a direct assault on the essence of dignity itself. It was argued that the Supreme Court has granted protection to such kind of intercaste marriages wherein the parents being unhappy lodge false report. The counsel for the petitioners Ram Bihari Gautam placed the reliance upon the judgment passed by the Supreme Court in the case of Lata Singh versus State of UP and another 2006 5 SCC 475 and Shakti Vahini versus Union of India and others 2018 7 SCC 192 para. On the other hand, State Counsel Yadavendra Dwivedi had vehemently opposed the contentions raised by the petitioners, but he could not dispute the fact that the petitioners are major and they have solemnized their marriage on their own free will. Para. The High Court pointed out that it is not in dispute that the petitioners are major and have married on January 9, 2026. The family of the petitioner 1 are attempting to initiate criminal proceedings against the petitioners and they have threatened the petitioners to implicate them in false criminal case. The Supreme Court has held in Lata Singh case as under This case reveals a shocking state of affairs. There is no dispute that the petitioner is a major and was at all relevant times a major. Hence, the petitioner wife is free to marry anyone she likes or to live with anyone she likes. There is no bar to an intercaste marriage under the Hindu Marriage Act or any other law. Hence, we cannot see what offense has been committed by the petitioner, her husband, or her husband's relatives.